All right, board members, we're going to move to agenda item 8 today. This is unfinished board business from yesterday's meeting. And to kick off here, we're going to jump back into R277-613, LEA policies and training regarding bullying, cyberbullying, hazing, retaliation, and abusive conduct. Just as a reminder, here's what has taken place with that rule. There was a motion made that the motion that came out of committee. There was a motion to amend that we strike lines 49 to 52 and replace with civil rights violations means violation outlined in the following federal laws. And then there was also a motion made that we strike the words that is prohibited from line 40. And then we had a motion to postpone. And so for today, so we don't need a motion to bring it back because we've already moved it to today, and that's what we're dealing with here. So with that, let's continue this discussion, and we've got a light from Member Boggess.
Thank you. So if it's acceptable to the group, I'm just going to start at the top. And I would move that on line 44, we insert the language, quote, accountability practices means the same as, however we do that language, Elise, the same as in R277609.
Yeah, please.
You said line 44, so we're not replacing line 44, we're just creating a new line 44 and pushing
Yes.
everything down? Okay, thank you.
Yeah, that accountability practices means the same as in R277609, or whatever is the appropriate rule writing language. I believe that's what I have seen elsewhere.
Okay, so the motion then is that the board insert on line 44, accountability practices means the same as described in Rule R277-609. Do we have a second? We have a second. Back to you, Member Boggess.
Yeah, so, well, I probably did these in the reverse order. Later, I have an amendment to 294 to insert the accountability practice language there, and we need this linked back to that definition.
Please.
I guess it's just a clarification of process. Accountability practice is in our definitions rule. And because, it's my understanding it is, in Rule 100. And
It's in 609. I do not find it in Rule 100. I could be wrong, but according to what we have on the internet presently, under our admin rules, it is not in there.
it may not have been, it may not be effectuated, but I know that we passed it. I'm just trying to see, do we need to include the definition here because it's in Rule 100? That's all I'm trying to
So
find out.
if it's in 100, that's okay, but I did not see it in 100. When I go to Services Board admin rules, I am not seeing it there.
But it was to Member Carey's point, we did have a discussion about adding it when we first talked about this. And so it might be in process. I don't know how long that takes.
And I don't know if it's in process, then maybe we have to proceed as Member Boggess is now taking us because it's not in effect. I don't know what the legal, when we pass it, is it law? It's my understanding it's not. There's that period that you can review it, and if it's not posted, is it law? And if the answer is no, then I think Board Member Boggess is moving us in the right direction. If it is law, then we don't need to include it. Is AAG... Does that make sense?
It makes perfect sense.
So I don't want to slow things down, but I also don't want us to...
So it's not, if you go to the board website, it's not listed here under definitions in 100. But if it's gonna be there within days, I'm totally good to not.
Superintendent Hart has a,
I was going to say.
Ben Rasmussen, Director of Law and Professional Practices. I'm showing that there was a version of 100 that was approved by the board and with a first possible effective date of yesterday. Deputy Superintendent Newey has approved those for finalization. I think at this point, we're just waiting for OAR to do the final touches before Karen can post those and make them final on the website. I'm not sure if that has this definition in it, but that's probably what we're dealing with here.
So we know it's going into effect soon, but we don't know if it includes the definition?
We can find that pretty easily.
I'm asking, not telling. Oh, okay.
Here we go.
Chair, may I interject?
It is in there. This was passed in June board,
Okay.
so there is a definition for accountability practice in there. There is? Yes.
Okay, then,
Elise, do you still want to interject?
I just wanted to say that it was made law as of yesterday. So it's not uploaded to the website, but it is now law. So we are good to go.
okay. Then with that, I would withdraw the motion, assuming there's no objection, and move on to the next one.
Any objection? Okay, let's consider it withdrawn. Continue.
All right, in line number 67, I move that we strike the word cause and replace it with the word instigate.
So there's a motion to replace the word cause on line 67 and replace with instigate. You want to speak to that motion?
Sure, I really feel like this is a better word. When you think about the logical chain of events, oftentimes we get caught up in what caused it as opposed to what instigated it, and they are significantly different. I think this represents a better chain of events for our school officials and our people engaged in discipline.
Member Carey?
I had a good conversation with Board Member Bogus, and in committee, I'm the one who made the motion to insert cause, and I did that because I didn't want to create a situation where the victim and the perpetrator were treated as equals, that the perpetrator should bear more responsibility, more weight, have more accountability. And I believe that substituting the word instigate for cause brings us closer to that objective. Thank you, Chair.
I'm stuck here. I don't know how to relinquish chair here. Amanda, will you be chair for a second? My concern is when you talk about instigate, if I tell you, Joe, or convince you to go slap Rod.
That would take a lot of convincing. Let me just put that
I know. That's why I'm trying to convince you instead of doing it myself, right?
Even with Randy, that would take me.
Cole, not so much.
Not Skip Cole, but that would.
I'm the instigator, you're the cause, right? Does that make that's how I'm hearing this. I would prefer the word cause. Because I'm in yeah, I'll let you chew on that, but that's how I would read this. Member Carey.
No, that makes sense. My concern, after speaking with Member Bogus about cause, is what happens if I say something that triggers or offends unintentionally a response? Am I then labeled the cause and carry responsibility for the actions of that individual because I've said something that with no intent to trigger a response did. And I think instigate eliminates that that area because there's almost like an intentionality, an intent behind instigate, where cause is just you could do that without intent. You ran the red light, you caused this accident. Where instigate, there is that element of intentionality, and that's why I prefer instigate.
Okay, so the motion then is that the board strike cause on line 67 and replace with instigate. Let's vote.
Lear's a no.
Thank you, Member Lear. That passes 10 in favor, 5 in opposition. Those in opposition being Member Wood, Member Lear, Member Booth, Member Reel, and Member Hymas. Okay, Member Bogus.
Thank you, sir. I'd like to move us to line 147. And I move to strike the language non-consensual and intimate and replace it with sexually explicit. On my draft, it is 147.
So the motion, apologies, the motion before the board then is that the board strike non-consensual and intimate on line 147 and replace with sexually explicit. Do we have a second? Second. Okay, we have a second. Member Bogus, speak to that.
My concern with the language non-consensual is that not all of our individuals in K-12 instruction are under the age of 18. There are women and young men alike that can consent to these images being created of themselves by law, but that doesn't mean they should be disseminated. And I think we need to be very clear that even if you do consent to the creation of them, you absolutely do not consent to the dissemination of them. Regardless, when it comes to school, it's inappropriate either way.
Yes. Go ahead, Chair. Hymas.
I guess my question, I'm trying to, like, I don't disagree with any of that. I'm looking at, this is a bullying, hazing, albeit wrong. Does it fit into the, this rule? Does that make sense? I guess that's my question to you, maker of the motion. How does it fit into this if I create a drawing and a teacher finds it? How does that bullying, hazing, I don't know what the other terms are, cyberbullying? Yeah.
So first of all, I did not put the language in that came out of committee. But secondly, the reality is it's not artwork or weird stuff. We're talking about, I don't know, we'll say, I got to think of a name who's not in this room. Ingrid. Ingrid has her boyfriend take pictures of her, and she's underage. And while she might have consented, regardless of her age, to that happening, it becomes bullying and hazing when they are disseminated for the purpose of doing those things. There's a line there that's crossed. And I do believe that Superintendent Newey spoke about how we're coming into compliance with this language with something, but I don't recall which one.
Follow-up, Chair, just briefly.
Yeah, Chair Hymas.
Just a quick follow-up. I hear you. We're not putting intimate images, right? We're not talking about a person anymore. I've been in education long enough to know that a sexually explicit image can easily be drawn on lockers, on tables, wherever, where you would not identify a person, but you know it's sexually explicit, right? And so I'm saying, changing that, we're now saying that's bullying. I'm not sure where it fits here. So I guess I'm speaking against the motion, not because I am in favor of any of this, but I don't know if it fits here. So with that, I'll
Yeah,
yield to the others.
Deputy Superintendent Nui, can you help speak to what Member Bogus had asked about? Was this in the wording that was used originally? Can you help us understand that? Did that come from code?
Yes, Chair, if I may, Deputy Superintendent of Policy, Elise Nui. So this came from a federal legislation, the Take It Down Act. And if Tanya Albornoz or any of our prevention team are online, they may be able to speak more intelligently to what that entailed. But
Come on up. You wanna go ahead and introduce yourself and speak to that? Thank you.
Thank you. Tanya Albornoz, Prevention Coordinator. This language was drawn from the federal Take It Down Act, which was passed to help address issues with AI deepfakes that are arising in schools. That piece of legislation was geared mostly towards social media apps and things of that nature. But as that federal legislation passed, then LEAs reached out to us and asked us to include it in this section as we were making changes to it.
Thank you. Member Bogus, did you have a?
One quick thing.
Okay, it looks like Member Earl.
I guess I'm thinking of non-consensual intimate images. Could that just be someone holding someone's hand and then someone posting that, or someone, gosh, we saw it with Coldplay, right? Someone kissing someone or not kissing someone, right? So those aren't sexually explicit, but they're still non-consensual intimate images. And so a deep fake could be a young woman who, someone said, oh, I want to create an image of me kissing so-and-so, and then distributing that may not be sexually explicit, but may be bullying, or so it's an intimate picture where it's conveying a bullying type of a situation or coercive type of situation, but may not fall under sexually explicit. Sexually explicit falls under this. But I just wonder if we're narrowing it too much, that we're actually not capturing some of the bullying that's going on that could be related to less offensive when it comes to the image itself, but maybe not with the person that it's being played out upon, right? So it could even be holding hands. It could be something very innocent, but then with the wrong person or situation lead to and the idea of non-consensual isn't sexually related necessarily. It's just not given permission for that image to be taken. And I'm just wondering about that, if that's maybe the reason why they went with that language federally, because it could certainly be a broader range of things. So.
Okay, thank you. Yes, Member
No,
Carey.
but can we see the federal statute that this is being pulled from, the language, so we can see what the correlation is in the exact language? Thank you.
We'll get it up. Leanna's just looking at it, and now she's finding it. But
Member Carey, did you have another comment?
I did. And I would say maybe the solution is we treat creation and distribution in the same sentence. And I think that's causing some issues for us, because the creation can be consensual or non-consensual. And so I would ask Director Rasmussen perhaps to weigh in on this, but would it make more sense to treat these as two distinct acts? The creation of non-consensual content. So if you have a third party taking a picture, or someone else, and there's no consent, that could be bullying. and then the distribution. But right now we're saying you both have to create and distribute, which creates an additional hurdle because you can create it, but if you don't distribute it, we don't want people, capturing and creating that content and then saying, well, this doesn't apply because I didn't distribute it. So I'm prepared to make, Director Rasmussen is shaking his head in the negative.
Director Rasmussen, do you want to come on up and answer that for us?
If I may, I was just going to say that I don't think that having these two together is problematic. I think if an LEA has a policy like this says that, which includes a prohibition on this, it doesn't mean that if somebody, that you have to do both to violate the policy. I think doing one or the other would still violate the policy.
Then why don't we just say or?
You could easily change that to creation or distribution. I don't think that would
Well,
be.
at this board, nothing is easy, but I understand what
Would that be
you're,
different than the federal code, or? I don't think that would be an issue.
right, but Director Rasmussen, what I'm saying is I don't want to even intone that both are required to fall under this anti-bullying rule. If you create it or you distribute it, that should be enough. And I think you should be able to treat them separately. And when I see the and, I believe it's you have to meet both elements of that.
Well, I think you could change and to or without any problem, if that's the concern. You do not use and or in rule. If you say or, that's the same thing as and or.
Okay. Then
I believe if we go back to where I think we are still discussing a motion, let's go ahead and go back to, so that might be something that we can address.
after,
But
yeah.
yes, let's stick to this conversation directly on this motion. It looks like we have Member Green.
Then I would make a substitute motion, if that's in order.
That is in order. Go ahead.
And the substitute motion would be to just a point of inquiry. If I make the substitute motion and it's adopted by the board, does it preclude a discussion on the issues raised in Member Bogus's motion? Okay, then with that, I'll make the substitute motion. And that would be that the board amend line 147 to read create. It says creation and distribution. Are we more comfortable with create and distribute? Okay, so, okay, creation or distribution. And basically we're replacing the and with the or. Thank you.
Okay, let's make sure that this gets written correctly. Does that reflect your motion?
Yes, it does.
And is there a second? Second. Okay, we have a second. I know we have some microphones on. Let's go ahead and, is there anybody that would like to speak to this motion specifically? Okay, so the motion is that the board amend line 147 to read creation or distribution. And with that, let's go ahead and vote.
Lear's a yes. Oh, no.
Looks like we have Davis and Earl. Okay, that passes unanimously. Let's go back to our motions. Okay, looks like Member Green, now we're ready to hear from you.
I was just looking up definitions between sexually explicit and non-consensual intimate. I do feel that the non-consensual intimate wraps around more of what would fall underneath the bullying, in my opinion. Well, and also just by definition, it just refers to the sharing or distribution of sexually explicit nude or partially nude photos or videos of a person without their permission, including imaging initially taken with consent but later shared without consent, as well as images obtained without consent or even without the person's knowledge through methods like hidden cameras, phone cameras, or hacking, etc. And I just feel like in the dynamic of bullying, that seems to be how it's used in this realm. And the sexually explicit implies, I won't read that definition. I'll let you guys do that one. But I think that can happen also with, in moments of consent, but the difference is that it's shared outside of that moment. So anyway, I would probably support keeping the other language. I would like to learn more if maybe I'm off on my thinking though.
Okay, let's go back to the maker of the motion, Member Bogus.
So there's technically no motion on the floor.
Okay.
If it's okay, I would just comment. My biggest concern is are prom pictures, girls with crushes, are those now considered bullying? Are we going to eventually, make illegal Mr. and Mrs. So-and-so from 8-year-olds? And it's a genuine question, because if this is where we're at and we use that language, that can be used in really nefarious ways.
Okay,
So I understand what you're saying, and I actually agree with you. My question is, how far is somebody with nefarious intent going to take that?
I guess I'd respond, thank you. I'd respond saying yes, absolutely. Any photo that is used to humiliate or bully, you know what I mean? Like prom photo, okay, I get a hold of, I keep picking on Joe, let's go somewhere else, right? But I get a hold of, let's say you get a hold of my prom photo and you're like, oh man, this is hitting the web, right? Yeah, if that's non-consensual, that could be a problem. It doesn't matter if it's intimate or not. It could come down into some other category, right? You can't use these photos, to what Jenny has said, to what Emily has said. You can't do this and start harassing or using it to beat up on somebody, for lack of a better term. So yeah, I think this still fits, and I think it still applies, if that makes sense. Prom photos, yeah, non-consensual. You can't just get those and start blasting them. And I would think that it would fall under some sort. I mean, because bullying is on there. If I'm using it, right, it would fall under single eye, right? If I'm taking that image, it doesn't have to be.
Okay, it looks like we have Member Green, and then it looks like Member Bogus is in the queue. Member Green.
Okay, well, I guess what I was going to say actually falls under line 148 then. Sharing a recording of an incident as described in that code. So, I mean, I would worry that, and I have been aware of when people are even, somebody shouldn't be friends with somebody else and then the picture is shared because they are friends, or they're getting made fun of because, or implied, or even to a level of bullying that takes place because they're getting teased that they have a crush on somebody or that they're dating somebody, and that image of them being in close proximity is used to bully a specific person. So I know that, I mean, even on the most not sexually explicit level of this argument, that type of picture can be circulated for those specific purposes. In that instance, does that fall under non-consensual intimate images? And I get to the maker of the motion, sure, or anybody else?
It looks like, yeah, and I don't know that we have a motion right now, but we're still having a discussion.
Oh, sorry.
All right, let's go ahead. No, You're okay. Well, go ahead, Member Bogus. Did you want to make a motion?
So
Then
I
you
would
can speak
just
to it.
remove the motion. There you go.
I don't know that we had a substitute motion. So did you want to speak to
Yeah,
what Member
I would
Green
make
had?
that motion again. But with regard to Member Green, I think then in order for that to qualify, we need to remove the word intimate. So we've got, I think Joe made a very valid point early on in that maybe these should be in 2 lines. Because what you're talking about is the non-consensual distribution of images for the purposes of bullying. But in that situation, that image would not be intimate. And so I see both points. My other concern is we're pushing a really fine line with the First Amendment here. And if, let's say, a young person posts on social media or Instagram, and all of a sudden that post is shared for the purposes of bullying, but they put it out there, did they inherently consent to the distribution for the purposes of bullying? I mean, we've got a logical conclusion, 50 permutations and 20 miles long. And we're in really weird space, in my opinion.
Hey, thank you, Member Bogus. It looks like we have Member Earl that would like to make it.
Yeah, so Representative Wilcox in this last legislative session ran a bill to deal with, and he calls it intimate images. If you go to age-appropriate instructional materials, here he adds the risk of sharing intimate images or personal information through electronic means. So the intimate images is, and I know he has been a advocate for making sure that we're educating our youth on the caution of, sharing images and that kind of thing. So that's the language there that he put into the child, in our child sexual abuse prevention area when they added that in, just an FYI.
Okay, and it looks like we were just looking up on Robert's rules. So since we had a substitute motion, we can't make the same direct motion. Is that correct? So
Okay. May I, Chair? We're trying to get back on track here. We had a substitute motion. Now we're just kind of talking to the overall idea of this right here. The substitute motion substituted the one that was on here, Member Bogus's motion. It passed unanimously to move forward. It says somewhere, when a motion is substituted and the substitute is adopted, it means that the original motion has been amended and by replacing its text with the text of the substitute. The vote is then taken on the main motion as amended. That is in its substituted form. Now, I don't know, we could just be spending time talking about processes here. Is there a motion that we want to bring something forward here? Member Carey's substitute motion essentially it did replace and with or, so it had nothing to do with this non-consensual and sexually explicit portion. So I would do a chair's rule to keep things moving. If we want to amend the motion to say replace or make a motion to say non-consensual, intimate, replace that with sexually explicit, then let's get it on the floor. We can debate. But right now we have nothing before us. Okay. So you moved that, and then we started having this discussion. So I want to make sure it's official. So if that motion is moved, we'll get a second, and then we'll start the discussion again.
I would like to move it for the purposes of continuing the discussion.
Hey, I don't need a reason why.
Okay.
If you want to move it, let's move it.
I think we need to get to a better place
I'm
in this
ready to
space.
move it. Yeah,
Okay.
okay. The motion then is that the board strike non-consensual intimate on line 147 and replace with sexually explicit. So it's back on the floor. We have a second from Member Carey. And then, sorry. Is anybody on? Well, we've got Member Bogus who's speaking to this motion, and then I've got you. Go ahead.
I don't know that I have anything more to say. I think we're in such tenuous space as this is currently written. And when our LEAs start making policies, I think we're in tenuous First Amendment space. I'm shutting up. I'm going to let you guys take it over.
Vice Chair Wood.
I'm just wondering if we have anyone from staff who can talk about this at a greater detail in terms of our prevention and what we're trying to do here. Yes, could if they have anything to add to the discussion.
Becca Ray, prevention specialist. So some of the discussion, it sounds like we are trying to address issues of cyberbullying, which cyberbullying is defined in code and in this rule. So that is to address the discussion of the whether or not to include the intimate images. There was also a question of the sharing and recording of acts, and that's specifically to address cyberbullying as well. But I think if we refer to that definition, that should answer some of your questions.
Thank you. Member Reel.
Thank you, Chair. Thank you for your that answer, because I think that's really important. That part about cyberbullying versus bullying, I think that where it's defined is important to note. But also, idea is, what if we put both? Non-consensual, intimate, or sexually explicit?
I could be crazy.
Most likely.
Most likely.
You chose to be chair, so.
We're fair. We are down on, what is that? VI? I don't even. I had it on my screen. 7. So there's 6 others before that, and I believe that sharing images is not new. We're not inventing something right now. We're like, why have we not thought about this, right? I believe that this is covered under bullying, that every LEA knows what that means, and even cyberbullying, and could include hazing, right? I believe that it's in, that's what I'm saying. I believe that it's in there. I appreciate this additional clarity of creation or distribution of non-consensual intimate images. I appreciate the clarity in there, but I don't think this is new, and so I'm not. That's what I'm saying. We can keep adding to it. I think it's fine, but I do think that we've got eight things here, and it says which shall include a prohibition on these things right here, and there's going to be many more that are not listed, is what I'm saying. So, Member Reel, I don't mean to say, hey, don't add, or I'm just those are my thoughts. So if there's an amendment to the motion, happy to entertain it. Yeah, well, that's what I'm saying. Bring it out. So please.
I just like to move this along. So I'm trying to find compromise here, and honestly, I hear the debates on both sides, and they both make sense to me. I think Member Bogus makes some really good points there, and I just think it's sort of like the best analogy I can give is in emergency management, you can plan as much as you want, but like every single scenario is different. So broad is better, but in this case, I can see arguments on both sides, and maybe it's fine to just point out both when LEAs are making their policies. All right, I'll make a substitute. To have it read sexually explicit or non-consensual intimate on line 147. And I wanted to also say that because of the cyberbullying versus in-person bullying, there's so much gray area, and every scenario will be different, that I do think broad is better when these LEAs are making policy, but I think at this point it's the best compromise I can come up with.
So the motion then is to, let's see, that line 147 read sexually explicit or non-consensual intimate. It's been seconded. Member Reel. You want to speak to that additionally?
I already did out of line, so.
you rarely have the microphone. I mean, this is your shot. Hollywood's listening. Okay. Seeing no lights, let's put this to a vote. Member Lear?
Oh,
We didn't catch that, Member Lear?
now can you hear me?
Yes.
Okay. I think the non-consensual is the part of it. We had an experience a year and a half ago where there was a non-consensual image posted. It was neither sexually explicit or intimate, but it was non-consensual. So maybe we're struggling too hard with all the sexual words. And the point is non-consensual.
Member Lear, I appreciate your comments. We're in the middle of a vote that Member Reel put a motion forward.
All right.
Let me, the motion then is that on line 147, it reads sexually explicit or non-consensual intimate in order to capture the concerns of all board members.
I got that. I'll just vote. And sorry it took me a while to get on there, but I just think we're over baking this. Thanks.
What was your vote, Member Lear?
I'll vote yay.
Thank you.
Or aye or yes.
We'll take all three. That passes unanimously. Back to you. I think we've got Board Member Bogus.
I appreciate that, Chair. If I could move us to line number 294. I move that we remove the words "take positive restorative justice action" and replace it with the language "employ accountability practices." I move that we remove the language "take positive restorative justice practice action" and replace it with "employ accountability practices."
So the motion then is strike from line 294, take positive restorative justice practice action and replace with employ accountability practices. Okay, back to you, Member Bogus, to speak to that.
I just think I could talk for days, but this is where 609 went, and we need to be consistent. And I'll just leave it at that.
Okay, seeing no other lights, the motion then is to strike from line 294, take positive restorative justice practice action and replace with employ accountability practices. Let's vote.
It should be
There's a no.
Thank you, Member Lear.
employ.
That passes 10 in favor, 1 abstention, 4 in opposition. The abstention coming from Member Davis, those in opposition from Member Reel, Member Lear, Member Wood, and somebody else. Member Bollinger. Thank you. Okay.
Okay.
So,
Are we back
your
to
light
me?
is on. Yeah, I'm looking for it on this request, but it's on. Go ahead, Member Bogus.
Okay, I move, if I could take us to line 304. I would move that we insert the words "written, informed" after "obtain." So it should read "and obtained written informed consent from the student's parents."
The motion is to insert written, informed after the word obtain on line 304. We have a second? Speak to your motion.
Well, it's different than a phone call. I think a lot of parents do not fully understand what is going to happen with their child. And and I don't know what kind of phone calls you get, but parents, before they consent to this, need to have a clear understanding of what restorative practice is going to be used, how it plays out, who is going to be present. And a lot of times when I have dialogued with parents about these situations, they said that they understood, but they did not actually consent. And their affirmation of understanding was accepted as consent, and they went through with it anyway. And so we need to make very sure that when we're going into this space, that parents are in the driver's seat. And I'll be done there.
I know I'm speaking too much here, and I should have.
Hey,
asked these
this
guys-
doesn't happen very often, so we'll let it happen, Chair Hymas.
Man, as a practitioner, please, let's call the LEAs. Please don't make me write a letter and wait for a response every time I need help with student behavior. That's right. I do the phone calls. I don't just take it upon myself. I know there's LEAs out there and school principals who are doing their best. We have policies, we have practices, we inform parents, we talk to them over the phone, we have meaningful conversations. I'd rather not on this one. Thank you.
Member Bogus.
So we're not talking about student discipline. You took us into a place we're not talking about. We're talking about, in particular, our code requires parental consent before being engaged in a, quote, restorative justice practice. That's there. Yes, I do, because we have schools abusing this, and unfortunately, we make rules for people who do dumb things, right? That's where we find ourselves a lot. But if it's not understood, it needs to be understood that you cannot use implied consent, you cannot use confirmation of understanding, that you have to actually consent to this, because, well, I would argue that often it is completely out of line, what they're doing, but that's a debate for another time.
Chair Hymas.
Yeah, beginning at 303, right, B, if an LEA would like a student to participate in a restorative justice practice, which could be anything from an apology to a written letter to, monetary reimbursement. A student if an LEA would like the student to participate in any of those things, the LEA shall notify the student's parent of that practice, and we're saying, and obtain written consent from the student's parent before including the student in the process. So I've got a first grader who splashes water on somebody in the hallway. And instead of saying, hey, I need you to be mindful of your situation and maybe apologize for getting them wet, I'm saying, man, I'm not going to touch this kid. I got to get written consent from the parent before I ask if I can have them apologize, make them aware of their surroundings, right? Again, maybe a poor example, but we're dealing with quite a spectrum of children. So again, that's where I am.
All right, looks like we have Member Earl and then Member Bogus is in the queue.
So and this is where this gets a little bit crazy, because and when we had talked about previously restorative practices, restorative justice practice, this is saying restorative justice practice. My understanding, unless I'm completely wrong, that wasn't accountability practices. This was a very specific outlined program, because restorative justice practices is different. At least this is what I was told when we were in the spring. A restorative practice is different than a restorative justice practice. This has very specific connotations, very specific follow-throughs and stuff. This isn't just someone pushed me down on the playground, you need to go apologize to them. That's an accountability practice, and that would fall under, I guess you could say, restoring or restitution, but that's not someone, I don't know, Someone help me. The restorative justice it's in law. It requires very specific provisions from what I remember. Am I wrong in what I'm saying? I'm just seeking, because both of them have justice added to it, so that it narrows the scope.
It looks
to
like we have some
a-
staff that would like to help
Yeah.
answer your question.
And if it's both of those, then we've got I don't think it was. When we asked about it, there was this umbrella, and then there was this spine in the umbrella, right?
Chair, if I may.
Yes, please.
Tanya Albornoz, Prevention Coordinator. So in 53G-8-211, there is a definition of restorative justice program that this rule is referring to. And it says it means a school-based program or a program used or adopted by a local education agency that is designed to enhance school safety, reduce school suspensions, and limit referrals to law enforcement agencies and courts, and to help minors take responsibility for and repair harmful behavior that occurs in schools. So because it says a school-based program, that doesn't necessarily mean that it's a program. It could be a program that's outlined by the LEA. So there is a spectrum of interventions that occur. Restorative practices are on the prevention side. Restorative justice is after an incident occurs, and they're trying to repair the harm that that incident has created. So that could be a set of interventions or activities that the LEA defines is part of their restorative justice program. Does that make sense?
Member
Sort of
Earl,
as-
did that answer your question?
Yeah, so it's a program. Or is it a way of being?
Go ahead.
Again, it says adopted by a local education agency that is designed.
It's not just the playground incident. It's something that's adopted. You're doing a specific program related to it. It has more intentionality about it. It's not just, at least in my view, that's what I'm hearing, is it's a very specific practice that you've taken on in your community, and parents should be aware of that if you're using that. So,
Okay, it looks like we have Member Bogus is next, and Member Davis is in the queue. Member Bogus.
I don't know that I have anything to say.
Okay, are you just?
I think Member Earl said it all, and
Okay,
very well, mind you.
Perfect. We will go to Member Davis.
I think you can adopt practices that are or are not in, some kind of published program. But again, restorative practices, restorative justice, two different things. But all of the pieces in the accountability practice are part of restorative justice practices in practicality where the rubber meets the road. So to Chair Hymas's point, that gets very tricky when you're helping a child make restitution for something that they have done, whether it be an apology or, they help do something together in the classroom, whatever it is, and there's no immediacy there because you got to call a parent beforehand. I mean, when I was a principal, I considered discipline as instruction. And so I didn't call a parent unless it was 2 times or more. There was a pattern because so much of it is just teaching on the fly as you're working with children. So, and as you're teaching, that one time take care of 90% of the problem. Like 10% of your kids are going to have a second time or more once they kind of learn this is how to treat other people. Anyway.
All right, I'm going to take back over because Member Bollinger wants to make a comment, and then we've got Member Carey.
Thank you, Chair. I just wanted to speak to this idea of obtaining written consent, because I absolutely do believe that we want parental consent if we are implementing restorative justice practices. However, just the complication of getting written consent and the timeliness of these sensitive situations where we're addressing these hard topics and things that are really affecting how students are functioning in school, I would be against adding written consent just for the logistical reasons and the timing. I mean, to Member Davis's point, when you're an administrator and trying to get written consent from several parents to have this move forward can really make this last weeks and weeks. And when we're talking about doing interventions and helping address concerns, the sooner we can do it and the quicker we can do it, the better, so we can get back to our learning. So that's just my opinion on that addition.
Thank you. Member Carey.
Just two issues here. So I don't look at this as you want student A to apologize to student B. I need to write home and get a consent from the parents. I look at this as the school saying, look, these are the restorative practices we use at this institution, right? We require apologies. We require accountability. We require the students to get in a circle and confess their sins. Whatever their restorative practice may be, they list it. And then they send that to the parents and say, if your child attends this school, these are the things we do, and this is why we do them. To me, that's the notice. I don't think this is a permission slip every time that you do it. I think that would be onerous and unenforceable and just lead to a overall just not a good practice. So the way I interpret that, and I would ask the maker of the motion, but I look at this as, look, these are the sort of practices we have. Your child comes here, they may participate, in things like this, and then if you have a problem with that, let us know, and they can opt in or out at that point. That's the way I see this. And the written consent, I think that's important. Like just this morning in law and licensing, we were discussing seclusion, and we talked about what happens when you call home and no parent is there to take the call. And I look at this as very different because in that case, you can't predict the timing of the incident. Here, we're just getting that consent early on, and to me it's sign it once and you're good for the year. But again, I would defer to the maker of the motion. That was my understanding of it. Thank you.
Thank you. Member Davis.
I think Board Member Carey answered my question because it sounded to me more like an awareness, not a consent. Like, so if you don't get a consent from a parent, and sometimes parents just don't sign stuff, then if you have an altercation in the hall, it gets a little tricky for some of those just things that you do every day on and off as a principal as you're just trying to kind of manage and help kids.
All right. The motion then is, go ahead.
Is it a one-time consent, or is it, because that would influence whether or not I would make an amendment to the language. So I'm just looking for direction from the maker of the motion.
To the maker, Member Bogus.
Thank you, sir. So a couple things with regard to that. One, it is in code that prior to a restorative justice practice, parental consent has to be obtained. And so,
Do you want that to take place every time, or are you saying that you waive that at the beginning?
so I believe that is in code. I read it as at the beginning of the restorative justice practice. And again, restorative justice practice is not school discipline. It's very different. As an example, there was an instance where a young lady was assaulted, and she was brought in to restore this relationship. This young man was brought in to restore this relationship. Eventually, she filed charges, and because his parents weren't notified, he had admitted to all sorts of stuff without legal counsel. And so when we are in this space and we are saying, hey, things are happening and we're going to restore this relationship, that boy should have had legal counsel. And that girl should have never been put in the position to restore a relationship with someone who had assaulted her. That just re-victimizes her. And so we are not talking about school discipline. We're not talking about the behavior matrix at the school, the intervention plan, the PBIS. We're not speaking about that. We're speaking very specifically, as Board Member Earl pointed out, at restorative justice practices. And in that case, I really feel like that young man should have had an attorney, or at least had a parent to say, no, my child's not going there until I'm sitting beside him. And that young girl should have never been put in that situation, especially without parental notification.
Yeah, if I may.
Yeah, Member Terry, go ahead.
Thank you. I believe me, I'm a firm believer in legal counsel. I think that the incident you referred to, the young woman would have been protected by the language in lines 300 to 302 that says a student, bless you, a student to whom an incident is directed is not required to participate in a restorative justice practice, blah, blah, blah. So if we're looking to strengthen that, I think we need to look at those lines. Here, I think we're casting a bigger umbrella to say the notice that you give, and again, it's like when you walk into a lawyer's office or a doctor's office, you give general consent to everything they do. Here, we're going a step further by saying, you know, they have to itemize the practices that they perform at that school. They would do that, in my opinion, at the beginning of the year. But I would defer to staff. If we keep the language as is and it says restorative justice practice and obtain written and informed consent, is there an implication of how that is operated? So when you read that, is it defined? Board Member Baga said this is defined somewhere else. Does it automatically conjure up this notion that you can do it at the beginning of the year and grant consent, or is it imply that before you can perform the practice? And if there's no implication, I think we do need to, if we decide to proceed down this path, address that. Chair, if I can direct that to staff.
Yeah, Leah, you have Dr. Voorhees, thank you.
Thank you, Chair. Leah Voorhees, Deputy Superintendent of Student Achievement. So our thinking is similar to Chair Hymas's thinking, that it would be per time, not like you're suggesting annually, or that it would be incident specific. Is that? Yeah.
Thank you.
Sorry, I meant to push my button, then I pushed something else into here because for some reason you gave me controls that I shouldn't have. So now we're voting on something. But let's clear that. Thank you, Kelsey. I know you should not have trusted me. The motion then before the board. Oh, I've got Member Green. I'm sorry. Member Green, go ahead.
I think that we're in a very interesting discussion right now, because we are actually addressing something that I think has been simmering in the education realm for quite a few years now, and it is the concept of restorative justice practices, which can actually be branded with the capital P program. It is programs, it's disciplines, it's practices, it's formal belief systems that are funded by, organizations, at very high levels. So if we're not liking, if we don't like that idea, then maybe it's that word that we need to address itself, restorative justice practices. There's a whole political movement based around that, and we know it. Capital P, program. It's a program, capital P, restorative justice practice. If that's the case, which under that name I would argue it is, then I would agree with a written consent, because that formalizes a very formal program and the practices that requires. So if we don't like it, then maybe we need to address restorative justice practices. If we like it, then I think we have to formalize it and require written consent, because then we start tipping into belief systems that exist in that program. Whether you like having to get that written consent or not from parents, If it's at that level, then I think it is required. So my question is that what lines 303 to 305 does? The way it reads and the way that it is being presented at all of these conferences and all of these teacher trainings and all of these curriculums, I would say, yeah, it is. It is a formal way to figure out controversial situations. So, I mean, I would support written consent as it stands because of the nature of the restorative justice practice program, capital P.
Member Carey.
Yeah, just to Board Member Green, I have no issue with the consent. It's just the frequency of that consent. So when I talked to the superintendents and other educators in my area, and I said, do you guys do restorative practice in your school? And their answer is yes. And I said, well, what do you do? And they said, well, if Johnny hits Susie, we ask Johnny to apologize. That's how they define restorative justice practice. If this were to pass, we're going to ask that teacher to reach out to the parent before they can effectuate that. So yeah, if there was a preset, we have them get in a circle, and I don't know what that circle's called, but restorative, like, okay, we look at restorative circle, yeah, that we need. But if we're going to say because our schools are defining this in a much broader fashion, and, when I was growing up, my parents didn't call, hey, you apologize if you do something wrong. They didn't refer to that as restorative justice practice. That was just the way you raised your kids. Today, a lot of educators and institutions call that restorative justice practice. So, again, I think that requiring that would be, I don't even know if it's doable, but just given the frequency that would happen in the school. So I like a list that they can sign off on, because then if you see something on that list, say, I don't want my child participating in that, then they don't have to. But right now with the everyday, I just don't think it's sustainable.
I have three of you. I'm always, as you know, I've got my eye on the clock all the time. I do want to remind this board, as we've been talking about consent, this motion is adding for written. It's an additional. The consent is already in there, right? You still have to get consent. So the debate is, do we want to take the time to get written consent? And then let's not even get started on what written means, if that's in an email, a text, or letter, snail mail, right? So again, the motion before us is to insert written informed after obtain on line 304. With that, Member Bogus, you're next in line, and then I've got Member Green and Member Kelly.
Well, actually, sir, you actually articulated what I was going to articulate. We are already requiring consent, and that would be verbal consent. But I work in a district that is pretty heavy into restorative justice practices, and they do not view, or I should not say that out loud. I have never been trained in such a way that typical discipline is considered restorative practices. That is not training that I have been involved in. When I have been involved in restorative practice training, it is very, for the lack of a better way of saying it, it's very narrow in scope, and those practices should have written informed consent, because especially at the high school, middle school, and high school level, and my response to the frequency, if kids are assaulting kids every day in the hallway, that is a much bigger issue than informed consent. And so we're looking at a space where this shouldn't be happening all day long, every day. This should be very infrequent. These kinds of restorative justice practices should not be happening on the regular. It should be an auxiliary event, not an ongoing event. I can't imagine in a school of 100 kids that you would have more than one or two a week. And even at that, your larger schools, if your little things are taken care of, these things should not be happening. So I don't view this as a cumbersome thing to schools or school administrators.
Member Green.
And I guess off of that, I would agree that if we're employing a specific narrow scope of labeled under and practiced under the title of restorative justice practices, that is very specific in when that is triggered and used. So my question then would be, does this rule address when a line is crossed as far as interactions between students? And if you give the example of a kid throwing water, does that action cross into this rule being triggered for that student? And I don't know, like if it's just that, hey, we shouldn't do that, that's not nice, say sorry, then there's no written consent. But if it goes beyond and falls into a heavier level where we can categorize it as bullying as defined, then it's just the nature of it is just different anyway and would require that as well. So anyway, that's all. Thank you.
Member Kelly. The motion before the board is that the board insert written informed after obtain on lines 304. Let's vote.
Learson, no.
Thank you, Member Lear. That motion fails. 9 against, 6 in favor. Those in favor being Member Brenton, Member Hall, Member Longacre, Member Bogus, Member Kelly, Member Green. Member Bogus.
Just have one final motion, and I'm sure you are going to be.
Is it non-debatable?
No.
Oh.
It is not one of those. On line 214, I would like to add a little I and a little II. I'm
sorry, which line?
214. That says including Tinker versus Des Moines on the first I. And in the second little 2 I's, the Connick versus Myers and the Pickering Connick test.
All right, let's make sure we get that correct before we seek a second.
So the first one is Tinker versus Des Moines. Oh, I'm sorry. The second one is Connick, Connick versus Myers and the Pickering Connick test. And I will double check, Ben, to make sure that I read my writing correctly.
So the motion then is to insert after line 214, I including Tinker versus Des Moines, and then double I, Connick versus Myers and the Pickering Connick test. Is that correct, Member Bogus?
That is correct, but I think including would be up and the I would be right before Tinker, just to be written correctly, but I don't care. Whatever Ben says is good.
Okay, so do we have a second to this? Back to you, Member Bogus.
Thank you. So I think that when we remember free speech in schools, we often try to train our children to believe that they don't have all the rights they actually have. And so just a very clear understanding of Tinker versus Des Moines tells us that kids have a lot of First Amendment in schools. It also talks about the barriers of free speech in schools, that which is needed to maintain decorum, all of those things, the suppression of free speech, what warrants a suppression of free speech is in the Tinker versus Des Moines trainings. And for teachers actually are, they have pretty restricted speech as part of their employment as a government employee. And the Connick versus Myers, it's 2 N's, I believe, Ben, but I could be wrong. the Connick versus Myers SCOTUS ruling addresses that. And when it goes through the courts, they conduct what's called the Pickering-Connick test. And I think that is really important in helping teachers understand not only when they speak, what kind of free speech they have, like if they speak on a public policy issue at a board meeting, they've got a lot of free speech there. When they are speaking inside their classroom, that's a whole other issue. And understanding the difference of the First Amendment between a private citizen and as an educator, I think is really important. And just putting those in there so that schools, teachers, students all have a very clear understanding of where we're at in this process is super important. Thank you.
Member Earl?
No. Just a question as far as writing rule. Do we normally cite legal cases in? I'm just asking, is that a common?
We're not citing it.
So this would be,
We're not citing
this would be that we are now training on these two cases.
Yeah. Okay.
As you're thinking, I just going to speak briefly. Member Carey, I see your light. I speak briefly. I'm not ready to make a motion on two cases that I'm going to ask the state to train people on that I'm not even familiar with. So I'm just speaking against this right now. I'm sure it's good, but I'm not there yet. Member Carey, go ahead.
Yeah, so, you know, and Tinker Des Moines, that's the famous landmark case where the two teenagers wore the peace symbol, I believe, on their armbands, and the court ruled they were allowed to do that. Connick, and I'm not saying this satisfies your, I'm just saying general, right. Bring that guy back with the robe. So, it's my understanding that Pickering-Connick is the test that basically said, look, as employees, even if you're in a school, you retain certain free speech rights. And that's been a long-standing free speech test for public employees in general and in education in particular. So the one thing I would point out here is that if we move forward with this, there needs to be a triple I, because I believe that the motion says, or the language here says, we teach the students, the teachers, and the parents. And so I see a case addressing the students' rights to speech. I see the Pickering-Connick test, which is the employees. I don't see a case that addresses the free speech rights of parents as outlined in our rule. Not asking, just saying like that, I think we would have to be addressed.
Yeah, go ahead, Member Boggess.
I think the First Amendment covers our parents.
It would also cover.
Well, and it would, but when the schoolhouse doors, when you walk through them, the Tinker versus Des Moines makes it very clear that you can suppress speech, but it has very clear parameters on when you can. And it's been, like you said, the landmark case for over 50 years. And when schools go too far, we see judgments, and those judgments cost the taxpayer. So I think that the First Amendment as the overarching thing covers our parents, but I do believe that these two are super important for our teachers and our students. And then I would just maybe kick back, Member Carey, do you have a suggestion for a landmark case? Because I know of district level case law, and I'm not an attorney, but I'm aware of district level case law. I am not aware of a Supreme Court case that addresses the parents' right to free speech in schools.
The only, Chair, if I may.
Please.
And I'm just speaking generally. So the reason that parents come to mind is that if I look at this, the one group that I think has really come under assault in terms of free speech has been parents, right? They're the ones trying to speak up and share their concerns, and, you know, labeled as instigators, problems, domestic terrorists. Even one of the districts, you know, they wouldn't even let parents speak at the board meeting until the legislature passed a law forcing them to do that. So I am concerned that that this doesn't contain, and yeah, I do think that because the rule, and what line is this in the rule? So because I thought it said something about educators, students, and parents. That's why.
Matt, can I speak when you have a minute?
Yeah.
I don't know how to raise.
No,
Thanks.
you're good. I got you in the queue. I've got member Carey, are you? I know.
Yeah, I'm done.
Okay.
Thank you.
I've got member Reel, then Vice Chair Bollinger, and then member Lear. Go ahead, member Reel.
I'm just going to speak against this motion. I think we're taking this a little bit too far for our rule writing. I think we have to remember that our LEAs are talented, smart individuals that are writing their policies. I think that we don't need to give such explanation and detail in this legal way. I think it's overkill. I think it's not creating any more clarity whatsoever. And a lot of our LEAs have their own attorneys that can interpret and understand the law and understand all this past precedent and law that we've seen. So I'm speaking against it. I think that we're going down a winding tunnel with no end, and I'd like to move forward. So
Thank you, Vice Chair Bollinger.
Thank you, Chair. I would also speak against this motion. I do think that it does become more prescriptive and oversteps our general oversight of education. The other thing I'm concerned about is that this is training not just of school employees, but of students, coaches, and volunteers. So we would expect then all of our volunteers to be trained on this. And I'm just thinking in practice what that looks like. Typically it's they do some online training type of piece. So what type of a burden this would put on to make sure that they're trained specifically on these two cases. So I would speak against this motion.
Member Lear.
Speaking as a person who's actually taught these legal concepts to teachers for 20 years, they are nuanced. There are many other cases that influence this. There's a case that follows Connick that actually narrows students or teachers' rights. So I think putting these in here is going to make this rule outdated in about 6 months. So I don't think it's necessary, and ditto what the rest of stuff that Sarah said. Thanks.
Thank you. So the motion before the board then is that on line 214, we insert including I, Tinker vs. Des Moines Independent Community School District 393 US 503, 1969, and double I, Connick vs. Myers 461 US 138, 1983, and the Pickering-Connick test. Let's vote.
Lear's a no.
Thank you, Member Lear. That motion fails. 10 against, 5 in favor. Those in favor being Member Kelly, Member Brenton, Member Green, Member Bogus, and Member Carey. Seeing no additional lights, Member Carey.
Just two motions that I have on this rule. The first one would be lines 20. Well, let me start. Did the motion that I made yesterday actually get voted on, which was to
The motions that you made were that did go through were on lines 49 through 56-ish, that area.
And that was to change the language.
We added replaced with civil rights violations means violations outlined in the following federal laws. So then it had those.
And that motion passed?
Yes.
Okay, thank you, Chair. Just going to lines 208 through 213. And the court has been very clear, and I'm talking about the Supreme Court, and Congress has been very clear in the groups that have these immutable characteristics that are given extra protection by the Constitution. And those are typically race, religion, sex, pregnancy, and Board Member Lear probably has the other two. But so when I read this rule, I see this catch-all of or other physical or mental attributes or conformance or failure to conform with stereotypes. I don't even know what that means in terms of, is there any limitation on that? So I would like to amend, I'm sorry, I'm speaking to the motion before I made the motion. So my motion is on lines 208 through 211, it should read, this language is already there, how bullying, cyberbullying, hazing, retaliation, and abusive conduct are prohibited based upon the students or employees' actual immutable characteristics as identified in federal and state law. Except instead of and, I would put or. What? Oh, those immutable characteristics identified in federal or state law. Yeah, that would be the whole. Yes, sir. And I already spoke to it, Chair, so I don't need to go on.
Let's make sure it's correct, and then we'll seek a second. So you are, there we go. Ben's still working on it.
Yes, sir. And I know that needs a second, Chair.
Yep. So, okay. So the motion then is to amend lines 208 through 213 and insert after actual immutable characteristics as defined in federal or state law, and then strike the remainder of the language after the actual. It's been, the motion was made. The motion has been seconded. I believe Member Carey mentioned that the motion has been spoken to. Vice Chair Wood.
Should that be 208 through 212? 213 refers to the right of freedom of speech.
It should be. Let's change that.
Thank you.
Okay. How do you want to see it? What do you guys see? Are you asking for the actual text in the rule? Do we have questions? Are we ready to vote? Let me restate the motion, and if I don't see any lights, then we'll vote. So here's the light. Member Davis.
Isn't there something in federal law, I could be remembering wrong? Okay, this is embarrassing, but remember the movie Mask? You have to give a 504 plan because there's a perceived disability there. I just don't know if there's a problem taking out the word perceived somewhere legally.
Is that directed toward our AAG?
Yes, Chair.
Okay.
Through you to her.
AAG Beal, please.
I guess the distinction would come down to, retaliation, hazing, abusive conduct, bullying, perceived versus am I bullying someone because I perceive them to be that way, even if they are not? Like if they fall under that characteristic, that's where perceived is a useful identifier, right? And as a principal, are you looking at this situation and I'm bullying Dr. Hart because I perceive her to be X and she's not actually X? That's where that distinguishment comes in.
Follow up, please.
So I don't know if this is for the maker of the motion or AAG Beal, but so then if someone perceives someone to be one of these things and in fact they are not, then is it now not bullying?
Personally, I would say it's still bullying based on those things. It's based on their their perception of it.
Does that answer your question, Member Davis?
I guess it just reads to me differently with the amendment, so I guess it seems like it would take that out. Someone was calling someone names of a, say, racial thinking, and yeah.
Member
maybe.
Carey?
Maybe this is helpful, maybe it's not, but if you're making fun of someone because you think they're Korean and it turns out they're Japanese, you're still bullying on the basis of race. You may have got the specifics wrong. So even if you think someone is a boy and they're a girl, the basis are those immutable those categories. So if you think someone is Muslim and they're not, but you bully, you're still doing it on the basis of religion. And so in my opinion, this would still apply.
Follow up, please.
That makes perfect sense, and I would agree with that. I just wonder then if we would need to take out students apostrophe. Students apostrophe, employees apostrophe shows ownership of those things. It's prohibited
Can I
based
speak
upon the
in-
students.
I'll put you in the queue, Member Lear.
Thanks.
If we took that out, maybe it'd work.
So you're saying you're potentially proposing an amendment to say, so it would read, how bullying, cyberbullying, hazing, retaliation, and abusive conduct are prohibited based on actual or immutable characteristics, and just remove. Is that we're just trying to get clarity here?
I would
Member
just
Davis.
say based upon character. I don't know. You all, I just, based upon all of the list that's in the federal law, can you just say based upon that list, and then whether it's real or perceived, it's not the student's race, it's any language that would pertain to that, even if the student doesn't actually have that thing.
We've got Member Lear in the
It would be the
queue.
basis of race in general.
All right. Okay, is that directed towards your, go ahead.
And my issue is with the expansion of what has typically been very predefined and set categories, and we've gone through this with several rules. And I think that those protections, those special protections, are reserved for individuals in those groups. So when we open it wide open to say, or anyone with a physical or mental attribute or conformance or failure to, there's no definition for that. To me, it's anything. And so that's why I'm saying, no, let's go back and say, if it's these things, we're reserving this rule for individuals who fall into this category, not necessarily somebody dresses up and goes to school and they insist on doing that. Well, that's nonconformance. And
I've got Member Lear in the queue here. Member Lear.
Are you ready?
I think so. I'm getting some side conversations, but they're clearing up. Go ahead, Member Lear.
I can't tell from what I see on the screen if Member Carey is proposing taking away the laundry list and substituting it with immutable characteristics. Is that true?
So it would say immutable characteristics as defined in federal or state law. So it's just consolidating them as defined.
And taking away the laundry list. And I would suggest that doesn't work for me. Characteristics that are listed are not immutable. Sex is not immutable. Disabilities can be temporary. They're not immutable. Those are the two that immediately come to mind. But religion doesn't have to be immutable. So I think you're doing away with a lot of those characteristics if that's what he intends to do, with using a not very well understood, more difficult word. So I wouldn't support this.
Thank you. Member Carey.
Member Green had also pointed out some concerns with that word. So I'm happy to amend my own motion if possible to even bring more specificity to this.
Yeah, an amendment is in order, yeah.
And that would be, let's strike immutable characteristics and the word actual, just so it reads, this language is already there, how bullying, cyberbullying, hazing, retaliation, and abusive conduct are prohibited based upon race, national origin, sex, disability, and religion.
Usually gender is used instead of sex.
So,
I'm an old-fashioned guy, so I prefer well, that doesn't sound right. So we'll just keep the, well,
That's not an excuse, Joe.
so the amended motion,
you're setting me up, Ben. What? So just repeat the whole thing? Okay, yeah, I apologize. So this language is already there, how bullying, cyberbullying, hazing, retaliation, and abusive conduct are prohibited based upon race, national origin, sex, disability, and religion. And the rest would be struck. National origin, sex, disability, and religion.
And one more thing, Matt.
yes, let me just make sure, Member Lear, that we have this amendment in order and seconded so we can move on this discussion. Is that okay? I've got you in
Sure.
the queue, though. You're up next after we
Sure.
have Member Carey speak to his
Sure.
motion. Thank you.
Sure.
So from what I'm seeing, there's an amendment to the amendment, and that is to, instead of having immutable, it would remove additionally. Man, this is all over. I know you're trying. I'm not blaming staff. I'm blaming me. I'm sorry. That sounded bad. I'm just trying to follow. I think we're removing students or employees and putting prohibited based on, and then based upon race, color, national origin, sex, disability. I think you had, did you have religion in there somewhere?
Yes.
And religion is in there. And I apologize, Member Lear. I know it's difficult when you sit in silence and don't know what's going on, but we're just getting this motion put together. We still got you in the queue.
Yeah, disability, I would, yeah. It's or, it should all, yeah, or disability. I did thank you. I did, Board Member Booth, just have race. But if they're both federally required, then, and that's why, yeah. So color apparently is also required. So Ben, if you, yeah, well, you were okay. Thank you, Member Booth.
So the motion, or the motion to amend the amendment is after based upon, insert race, color, national origin, sex, religion, or disability. And then strike the remainder of the language. That's the motion to amend. So do we have a second for that? Second. We have a second for that. Do you want to speak to this motion, Member Carey?
I think I already have, but thank you, Chair.
Okay, Member Lear.
just so member Carey's aware, Title IX definitions say that sex includes sexual orientation and the other, well, gender, but the other one that member Carey was trying to get rid of.
Point of order. Go ahead, member Bogus.
We've got to keep it to the issue. She's implying intent, and Robert's rules clearly says you cannot accuse someone of intent. You have to keep it to the issue at hand. And so I would just ask that we keep it to the issue at hand.
And I apologize. I was not intending that. I was just saying, so I had no intent. I was just saying that there is a definition where sex includes the other two that are being eliminated, just so we're aware.
Okay. Thank you. So the motion to amend the amendment is that the board amends, or sorry, that after based upon on 208 to 212, insert race, color, national origin, sex, religion, or disability. Strike the remainder of the language. Let's vote. Member Lear?
Oh, yeah, I'm sorry, you say voting? Yes, I'm a yes.
Thank you. That passes unanimously. Let's go back to the original amendment. Remember that the one we just passed was an amendment to an amendment. So let's piece this together. Well, I guess I could ask, hey, Member Carey, was that an amendment or was that a substitute motion? Read. That's what I want to hear. Okay. So, I know I should have been like, was that an amendment or Okay. So, because now we don't have to vote on the same thing twice, I had misunderstood what was going on here. That is a substitute motion. And so that is now part of rule that passes. I'm going to go, I know Member Carey, for the board's information, and again, apologies, looking at the clock, and we're going to have some discussions of what's coming up, but there was a motion made yesterday that was tabled along with the rule itself that we have not addressed, and I would like to, because it was made and never resolved, remind or bring this back up to the board. The motion to amend was made by Member Carey, seconded by Member Earl, if you remember, that the board strikes lines 49 through 52 and replace with the following language. Civil rights violations means violations outlined in the following federal laws. So that motion is before us. I'd like to to bring it before us now, bring it back before us so that we can tackle this before voting on a final rule here. So is there any additional discussion to that motion that we had discussed yesterday? I'm not seeing any. Let's cue that up for a vote. Did we have something inaccurate in there? Is this the original in front of us and the one in the document is inaccurate? Is that what I'm hearing?
Because it was lines 53 through 56.
49 through 52. So it says strike lines 49 through 52 and replace with the following language: civil rights violations mean violations outlined in following federal laws. That's what I have. I'm going to, I know time is crunch. I want to get this right. Can we take 2 minutes? Member Carey, can you go visit with staff and make sure we got it? Okay. Okay, so this is it right here. Can we, and then 49 through 56 that's on the screen, is this what's currently in the rule that we're looking to replace, to amend? I'm sorry. Okay. So with this, it would, instead of saying for the purposes of this rule, civil rights violation means, it would just say civil rights violation means. Is that accurate? Yes. Okay. So once again, before we go into voting, the motion then is to amend lines 49 through 52 and replace with the following language: civil rights violation means violations as outlined in the following federal laws. Member Bogus.
I believe the word that we want is strike, that the board strike lines 49 through 52 and replace.
Yeah, I don't care. It's going to be the same effect. Let's cue this up for voting. This voting is open. Member Lear?
Yes.
Thank you. Oh, Member Lear was a yes. Did we get her, Sarah, did we get her recorded? Okay. Okay, that passes unanimously. Member Carey?
I move to strike line 215.
Motion to remove or strike line 215.
Yes,
You
sir.
can see that on your screen. Is there a second? Yes. It's been seconded. Back to you, Member Carey.
Yeah, so safe digital citizenship, I don't see that we've defined that anywhere. And when I just did a general Google search, there are way too many definitions and interpretations of what a safe digital citizenship means. And I think it's too ambiguous, and the ambiguity doesn't provide any guidance. Therefore, I would move to strike. Thank you.
Thank you. Member Reel?
I think we may, Chair, I think we may have a definition. Well, I mean, we teach, this is part of our standards. Member Earl, Member Green, and I went through a lot of the safe digital citizenship in our CTE courses. So I'm not sure if it is defined or if staff know, but it is something that we use in our standards and teach our students. There's an entire course on it.
Thank you, Member Reel. Can we ask staff why this was added, or maybe was this in committee? I'm not sure. Do we know why this was added? And I don't think anybody's saying, yeah, we need to get rid of safe digital citizenship. I'm sure it's going to be, yeah. Oh yeah, never mind. I mean, overall, we're. Yeah. Yeah, Leah, thank you.
Leah Voorhees, Deputy Superintendent. It is referenced in R277495, and then it is also in code, which we're trying to find the reference for you right now.
Please, Leah, let me get your mic going. There you go.
Thanks, Chair. 53G71202 defines digital citizenship as the norms of appropriate, responsible, and healthy behavior related to technology use, including digital literacy, ethics, etiquette, and security.
Will you read that code one more time?
Sure thing. Digital citizenship means the norm.
Sorry, the code.
Oh, the code, sorry. 53G
Okay.
dash 7 dash 1202.
And what section? Do you have a section, subsection?
1A.
Oh, yeah, there it is, right on top. Thank you. 1A. Let's get, I know, we'll decide later. Yeah, member Carey, go ahead.
Then my motion would be a safe digital citizenship as defined in 53G-7-1202, subsection A, subsection 1, subsection A. Thank you.
Okay.
Thank you, Dr. Voorhees, for tracking that down.
Is there any objection to adding this to this motion? No objection. We're going to move forward as this is the motion then, that the line 215 would read safe digital citizenship as defined in 53G-7-1202, section 1, subsection A. It's been seconded. There are no lights. Let's vote.
Lear's a yes.
Thank you, Member Lear. That passes unanimously. We are back, I believe, to our main motion that reads somewhere. The board approve R277-613 LEA policies and training regarding bullying, cyberbullying, hazing, retaliation, and abusive conduct. Draft 1 as amended on second and final reading. Let's vote. Member Lear?
Yes.
Thank you. That passes 14 in favor, 1 in opposition. That opposition coming from Member Bogus. That takes care of one item. Can we get a what? A round of applause? Yeah, we need one, huh?